Hi, everyone. My name is Brax Montier. I'm with UFLTV, and I'm here for another interview with Dr. Kim Openshaw. Uh, Dr. Openshaw, do you want to tell us what uh, the PowerPoint that you've prepared for us?
Yeah, what we're going to do today is look at what I'm calling part one of child custody evaluations. It's going to be some of the information you're going to already know. You're going to say, oh, why am I listening? But I want to bring up some points too as we go along, at least for us to begin pondering and thinking about this issue of child custody. So if I look at this, you can see here, um, one is, what is the primary motive? Why do people really go in and want a child custody evaluation? And are we just getting too many cases and they're not being very well screened and looked at? It's kind of like, okay, you want a child custody? Let's go ahead and have a child custody. So we're going to look at that for a minute. And then we're going to go in and look at a few, I know there are a lot more than this, but a few of the key historical factors that have brought up and changed our view of children and how we do child custody across time. Now, one of the things I want to say, though, Braxton, and cut in any time you'd like to, is we have to remember that there's what we call a historical lag. That historical lag means when something new is entered into society, whether it's like through legislation or whether it's just through social commitment, whatever it is, it takes 20 to 50 years for that to really become a new tradition. Well, consequently, we've got these overlapping systems going on because we get one is coming in, and before it starts to go out, another one's coming in, but it hasn't processed. So we have these periods of time in which those two are intermingling with each other, and it really causes a lot of confusion. And so as we talk about some of these issues that have come up across time, you're going to see that uh, historical lag, and maybe some of you have experienced that historical lag. We're going to look at some of the elements of what we call the best interests of doctrine. When was it brought in? How was it brought in? And things like that. Question then is, how can I file for a child custody evaluation? And we're going to get into some in terms of the custody evaluator and requirements for them to do such, and how are they selected? And just beginning according to Rule 4-903, a custody evaluation begins to take place. Now, the stumbling blocks, I'm going to actually be presenting them as we go through, and hopefully you'll jump in too with ideas as we go through.
Yeah.
So let's go to the first one.
All right.
Somewhat along the same line as what I was talking about is in terms of this historical is that when we recognize and look at change that takes place, that change happens on a social level, a political level, and our social political level. And then the question then becomes, what drives the seeking of custody of children? And over my years of experience in looking at this, you know, granted, there are some that I think are really justified. So many of them boil, I say one thing, but we can use multiple terms for those one things: power, control, dominion, and ownership. And these have not changed across time, although they may have changed hands from fathers to mothers across this time period. And often these are driven by money. And when we think about money, money becomes I
Um,
don't know many I talked to that said, well, I've got to have a child custody. How am I going to have money to raise these children? And then I look at the in my own family. And I say, how much of that child custody money is really going to the children? And oftentimes, if I ask, certain people about that, they're like, "Oh, well, I have a house to pay for, or I've got a boat that I've bought, and of course, that's for the children." And it's amazing. So, money is a very critical point. I don't know if you've seen that, Braxton, or not.
Yeah. I know money is something that a lot of people focus and hyperfixate on, and kind of take in as a core element of their being. They really how they like measure themselves against other people. And I can see why that would be a lot of it would really feed into the power, control, dominion, and ownership kind of aspects of of personality, regardless if it's the father or the mother. And a lot of the people that I've talked to, one of their biggest concerns regarding alimony or child support in a child custody situation is how much of that is actually going to my kid? How much of that is actually supporting my kid and not, paying for his new sports car or,
Yeah.
her beauty treatments or however it, whatever the accusation is. So,
And the problem I have is I don't see this being ferreted out before we go ahead and grant a motion for an evaluation.
yeah.
So just one man's perspective, I guess. Okay, so if I put this cartoon in there, thinking, you go back in time, and our social, philosophical idea of things, and we do have some archaeological evidence that societies, men have maintained the position that anything that serves their interest belongs to them and any position, whether it's women, children, slaves, all of those are their property. Now, I'll give you an interesting example. My great great grandfather was a German Jew, which one would think, well, by that case, I should have some Jewish component to me. But the Jewish uh, family organization is matriarchal, not patriarchal. But even in those situations, in matriarchal societies, for the most part, men still have this power of possession. Um, and so what that means is because my great great grandfather did not marry a female who is a German Jew, I can't claim Jewish heritage.
Hmm.
And so it's kind of an interesting kind of thing across time.
Yeah, that is very interesting.
Uh, Political.
Yeah.
Okay, I cut you off. I'm sorry, Braxton. Go ahead.
No, no, it's all good. We can just continue. I didn't really have anything to say.
Okay, so I'm going to try and move this out of the way a little bit here. Okay, so early laws, and they would even go back. You could look at this in terms of the Greeks. You can look at this in terms of the Hebrews. You can look at this. Um, Now, how many divorces were there back at the time of the Roman time? You were a Hebrew and you got a divorce. Basically, the man would come in and say to the woman, I divorce thee, I divorce thee, I divorce thee. And three, that nature says, you're out of this house, you're gone. So there probably wasn't a lot in terms of child custody. You have to remember that this comes out of a social nature from many, many years forward. Well, later on in time, we get the English absolute custody rights. And what that meant, as long as the father wasn't a drunkard, as long as the father had uh, bringing in an income, he was granted rights to the children. Now, in this time period, children were viewed as kind of miniature adults who are on the upper end of the economic scale. You'd see them dressed like little adults. They would be paraded around like little.
Yeah. They always had kind of the
In
kid
the
version.
area of a slave.
Yeah. So,
Yeah, and in fact, I have a hot tub at my home here. Um, the English people had hot tubs too. But the interesting thing is they had to keep a fire going underneath them. But it was too, there's such a small crawl space that an adult couldn't get through. So guess who stoked the fires of the hot tubs?
the children.
Children.
Yeah. They also had to do
Yes.
crawl into the crawl spaces of like machinery during the Industrial Revolution because they're the only ones small enough to do it. They also got a lot of jobs as chimney sweeps because they were the only ones small enough too. So yeah,
Yes.
they were used as
To,
assets.
to be the Santa to go down.
Yeah.
Yes. And so, even though we see some of these laws making some changes, it doesn't mean that they were very radical. Well, between 1630 and 1830, again, we started seeing some changes. Now that's 200 years, but children were viewed as economic assets. We talked about that, and property. And if there were a custodial issue that arose, children were awarded to the father. Now comes the common law of coverture in the 1800s. Now, this is again one of those laws that comes in, gives women some rights, but at the same time doesn't really give them any type of equitability of ownership. So women were legally one with the husband, but marriage was kind of set that way too. Oftentimes, regardless of the Christian church, it's, leave your mother and father and because one, cleave unto one another. Uh, but when it came down to owning property, they were still left out. And children continued to be viewed as property. And so they didn't have any rights to children. But again, divorce during this time, I don't think you'd ever find a child custody evaluation that was written in the 1800s. So it's really more of a 20th century phenomenon.
Yeah.
Well, let's look at the 18th century and the early 19th century. The Commonwealth versus the Addicts Court decision in 1813. It brought forward what's known as the tender years philosophy, supported the idea that children were unique, that they really weren't miniature adults, that they really shouldn't be under stoking the fires, although they still continued to do so. Uh,
Yeah.
they actually had a status above a servant, and notice here they were economic assets. Now, the tender years philosophy, we go into the 19th century, it it began to say, children really aren't as resilient as we think they were. And children, the developmental psychology of children has changed ideas across time. When I was young, uh, Dr. Spock, not the one on Star Trek, but Dr. Spock was the guru of child development. And he all children the same. A, B, C works for this child, do A, B, C for this child, and not really recognize differences in children. But in about 1980, somewhere around there, between that and 18 or 1990, came Barry Brazelton. Now, Barry Brazelton was a very forward-thinking pediatrician, and he replaced Dr. Spock as the doctor of the world, so to speak. And he said, no, you got to think about this because children are different. They are unique. So coming back to this, this Commonwealth versus addicts idea and the tender years doctrine, that they were unique in their own right, and an ABC philosophy is just not going to work. And anybody who's got children will know that. So, but there was an interesting thing about the tender years doctrine. Now, the tender years doctrine basically said because children aren't resilient, because children can't care for themselves, because children are being breastfed, what really that means is they need to be with the mother. So we see in the 19th century some presentation of divorces, some requests for custody. Again, really not much in terms of custody evaluation, but requests to the court, I want custody. And the court says, oh, no, this tender years doctrine is there. But as soon as the child got through what was called the tender years, which is about till the age of 2 or 3, when they no longer nursed, they became property of the father.
Okay. Yeah, that kind of um, is a little different than what I've heard about the tender years doctrine, where it was really the courts just kind of ended up siding with the mothers more often than not, and then awarding custody. I didn't know that after a certain point, there was like a defined age set for the tender years, and that it would revert to the father. I thought that they had just um, sided with the mother, and then that's just how it was.
And
So,
and later on, as this went through, you see the tender years law has really governed our philosophy of children for over 100 years. The further along we get historically, the less we begin to see this, well, this child has to be nursed and things like that, needs to stay with mother. The less we begin to see that being presented and then being put to the father, and the more we begin to see it taking dominance of the mother is the caregiver, nurturer. Dad's out working, earning. He doesn't have time for the kids. He can't give them the type of developmental things that they need, that their self-esteem becomes established, that they, get to school and helps them with their homework. No, the mother does that. That's her role. And so all of a sudden, fathers started being taken out of the picture. And even though we say, well, the court's looking at this decision, I believe that there was a mindset already established, and that mindset was the philosophy. And even among those in the later 19th century who began doing child custody evaluations, and the questions that were asked, in fact, you'll see in a minute when we talk about the best interests, you begin to say, oh, I can see how that could be swayed, that this is really the mother's domain.
yeah.
And so now, if a child wants to live with the father, but the custody was given to the mother, the child has to be a minimum of 14 years to be able to request a change in custody.
Wow.
Now, how will children really begin to do that? I mean, they can do it earlier, but will the court really listen to them? The last
Probably
thing I
not.
read was 14 years. But by that time, how well indoctrinated are these children? Especially against the father in some cases. So, tender years law, had a tremendous effect. Then we come into 1906. There was a publication by Keyser. I don't know. Are you aware of that publication, Braxton?
Oh no, I've never heard of this publication.
This
No.
publication is called The Law of Marriage and Divorce. And basically, what it did is it gave tremendous support to the mother's privileged custody relationship with the child. And it supported the tender years doctrine. And so here now we get it's kind of like when you go into a courtroom and you use previous cases as evidences for the reason you're asking for this. Well,
Yeah.
now we've got this publication. I don't know how well researched it was, but this publication, and they begin using this. Well, not only is there tender years, but here's this, Dr. Keyser who has written this book, and he says this is the way it should be. So we see the tender years continuing to predominate the influence through the 1970s. But remember what I said, even though in the 1970s we're going to start seeing some change being brought in the later part of the 70s, it's going to take some years for people to catch on. If we go to the early to the mid 20th century, we start seeing now divorce cases on the rise. Uh, we get now we have this no fault divorce. Before there was fault divorce, and of course I'm going to watch for everything I can to make reasonable cause for why I deserve a divorce. But that reasonable cause was also used as a reason for why I should have the children. Now we get into the no fault. And I chuckle because I've not seen too many no fault divorces, because in the background, what you're still hearing is, well, this guy's this way and this woman's this way. And it, we still see them struggling for fault.
Yeah, there hasn't been a really true no fault divorce where everybody just kind of claps their hands, go, okay, well, we gave it a good try. It just doesn't work. You know, you were great, and then they walk in different directions. It's
Yes.
kind of always, well, he sucks, he's a narcissist, or, she's crazy, or, he's a liar, that, whoever cheated. There's always something. Usually there's a reason.
And the thing that's really sad, Braxton, I don't know if you've seen this, but this has been something I've noticed, is they always look for the worst case scenario on the person. And the one thing that now starts popping up is, oh, he must have sexually perpetrated on this child. Yeah, he bathed them, and when he was bathing them, he used a wash rag and he bathed their genitals, and so he must be a pervert. And so we're starting to see that. And of course, that brings in sometimes the child um, protective services into the same thing, and maybe legalities start coming in. And it's a sad commentary that we allow that to occur.
Yeah, I mean, it's one of the like 101 moves in a divorce playbook. Accuse the other person of beating you or your kids, or of sexually assaulting you or your kids, or anything like that. And I think the reason why a lot of people do that, they realize how horrible it is, but a lot of people are getting caught for it, that didn't in the past. So
Yes,
now everybody is kind of thinking about it. It's on the top of people's minds.
right.
Um, and I think it's just like you said, the worst case scenario. They go, oh, what if that person's a pervert, or an abuser or something like that? And it's a lot easier to just throw it out into the wind and see if it sticks, rather than like actually finding evidence.
Yeah. And if it sticks, it just does so much damage. But
But yeah, whether right or wrong, if it sticks, that person's reputation is ruined.
well, and I'm thinking damage as it sucks down to the children,
Oh
be-
yeah.
because now they're saying, oh gosh, this person must do that. Let me give you a personal example. I shared this with Eric. Um, you know, I haven't seen one set of my grandkids for, I don't know, 7, 8 years, maybe longer. And I remember when I saw them last, their mother had said, uh, don't eat at your grandpa's place, because if he feeds you, he will poison you. Now,
that's that's crazy.
yeah, It is crazy. But
Yeah.
the courts have sustained this woman's right to the children. My son hasn't seen the children for as many years as I have.
Mm.
And so it's these are the kinds of things. Now, will those children be influenced in their life because of the cutoff of the generational connection and the
Yeah.
connection with their father? Damage will be significant, you know, and and we see then that being transmitted transgenerationally. So we know in the mid 20th century, we start seeing this increase in divorces. 1970, we see an increase. 1980, we see an increase. 1990, we see it kind of starting to level off. But honestly, we're getting about one divorce. If you look first, you have to watch the statistics because it isn't really a 50% divorce rate, one divorce to one marriage kind of thing. That isn't really true. It's really high. But when I add in second time divorces, third time divorces, and fourth time divorces into that statistic, then I
Hmm.
begin to say, oh, that's exactly right. We've got a very significant divorce rate. Well, and we do, but we've got to look at all of these areas. Well, okay. Tender years continue to govern the court decisions in the mid 19th or mid 20th century. However, the complexity and the variation in the types of cases that come before the court meant the court now was left not on their own to make decisions. In fact, they started to back off, I think, from a responsibility that they have. Uh, on one hand, they continue to maintain the responsibility of ordering it and say, yeah, we're going to do this. On another hand, they have removed themselves from really definitively defining what it is that these people are asking and why it is that they're asking for divorce. And so we see an increase in custody evaluations. I'm going to give this to this custody evaluator. Uh, and you'll hear me say this in a minute again, so I apologize for repeating myself. But there is no certificate certificate for a custody evaluation for a substance abuse counselor. Yeah, there's a certification that they have. There is nothing for a custody evaluation, and we'll talk about that in a minute. So rather than kind of this carte blanche maternal decision, a more refined view of the tender years law arose, and it says, okay, we really need to do a custody evaluation. That what that's going to do is that's going to give me, the judge, a better understanding so I'm able to make a decision. So 21st century, we see approximately one divorce for every 3 to 4 marriages, which is pretty high, about 25% anyway. With the
Yeah.
rise in divorces came an increase in custodial disputes.
Mm.
And as these disputes started to come in, the philosophy of the tender years became challenged. It just began to say, this can't go through and keep this kind of philosophy. It just isn't going to work anymore because we got too many variables being added into the equation now.
Yeah.
We begin to see terms being legalized, such as uh, legal and legal physical, legal custody. So we're getting, if I can have legal custody, but not physical custody, that can be shared physical custody. So we start getting all of these terms coming in. And my opinion is as we begin to expand the books in terms of how to make decisions, in trying to define and to make it more accurate, we become less effective and less efficient on behalf of the children.
Yeah. Yeah. If you have to worry about every different, all of the different variables, the process is going to slow down and the backlog is going to build up.
Well,
Whereas,
wait a
yeah.
minute, wait to see what we're asked to do.
Yeah.
So during this time, then we start getting the best interest of the child. That came out in 1989 in the U.S. Convention on the Rights of Children. It's called Article 3, the Children's Rights Principle. And
Mhm.
so this became the basis of the best interest philosophy. And I'm going to pull out just a couple pieces of it here. It basically says in all actions, so anything that has to do with children, whether undertaken by public or private social welfare institutions, the courts, the law administrative authorities, or legislative bodies, the best interest of the child shall be a primary consideration. Now, tell me, how long do you think it took before public and private social welfare institutions, courts of law, and that really begin to conceptualize? And have they a clear conceptualization of the best interest of children?
Probably not until like 2010. That would be my guess.
Yeah,
So probably uh, if that came out in if the UN decision was in 1989, so probably 25-ish years
yeah.
before.
And then even then, honestly, if you were to line up, here's a social worker, a marriage and family therapist, a psychologist, a psychiatrist, an attorney, a judge, and say, okay, write down what the best interests of the child are. Do you think they would come up with the same common description?
No, I don't think a single one of them would agree.
No, and that's a
Yeah.
problem.
Yeah.
So now we come down to assessing, though. Here it says all actions concerning children need to be taken in consideration. Now it's talking about assessing the best interests of a child means to evaluate and balance all elements necessary to make a decision in a specific situation for a specific individual child or group of children. Can you begin to imagine? Okay, so you come into my family when I was younger and I had 9 children. Um, what do you think that would be like? You're going to evaluate every one of those children. Now, I'm not saying it can't be done, but I'm saying, is it done?
I don't think on average it is done, but I think that it would take. You're right. It would take a long time. It can be done, but I don't think every single custody evaluator is doing the exact same level of evaluation for each kid.
No.
Especially if you have 9 kids. That's uh, that would uh, that would change the amount of work needed to be done by orders of magnitude.
Yes. Now, consider this idea. The tender years is still a philosophy that's brewing underneath everything, okay? And
Yeah.
you've got the best interests here. So now I'm going to split, the evaluator says, I'm going to split the children. I'm going to give these older children to the dad, which is basically a tender years philosophy, not a best interest philosophy,
Yeah.
to the dad, and we'll give these children to the mother. And sometimes it's an appeasement process, not a good clinical evaluative process. What happens when I do two things? I've already got a divorce that takes two parents who really have these children, ought to have some means of working together for the best interest of the child. But now I've separated their siblings from them. You
You're
know,
gonna put them on two different paths, essentially. I
yeah,
mean, yeah, one's gonna have one group of kids is gonna have way more fatherly influence, and one is gonna have way more motherly influence, and the course that they were on is gonna completely change.
well, and one of the things, Braxton, is how important is self-esteem?
They're incredibly important, not
Okay.
just very important.
If you want to go back and read my 81 or 79 dissertation and the research that came out of it is published later too, what you find is there's this crisscross match that adolescent males need more association with mother and adolescent females need more association with their father to foster a good basis of self-esteem. No, what if I disrupt that?
Well, I mean, they would severely lack in their the cross of um, the mother and father relationship. The
Yeah,
female children wouldn't get the kind of stuff that they need from the dad, and the males wouldn't get it from their mother. They were split like that.
yeah, and I'm not going to say that kids aren't resilient and many of them will come out just fine
Yeah.
regardless of that. But there are those children that it's going to affect. We looked at 30,000 adolescents, and that's what we saw. So kind of a big number of them. Okay, here are the points on the best interests of the child. And I've highlighted the one in red because I really think rather than just kind of listen them out, they really ought to prioritize these. And I'm going to go to this slide and the next slide first, because I think these are the first two most essential questions. Can this parent provide the care, protection, and safety of the child? No, what if they both can?
Well, then you have to get into nuances.
Yeah. Okay.
Yeah.
Well, the other one here, embedded deeper down in, says situations of vulnerability, the risks the child is facing, and the sources of protection, resiliency, and empowerment. Okay. In other words, I guess what I'm saying here is if if a custody evaluation is going to be ordered, wouldn't you think that these would be two of the most significant questions to ask?
Yeah.
Can these parents do this? I mean, if one of them definitely can, then I don't even see why we need an evaluation. But if they both can, in in the larger picture, if they're both able to do that,
Yeah.
why am I going to order custody evaluations?
Hmm.
Anyway, that's just kind of a thought I've been thinking about.
Yeah.
Oh, so if I'm going to do one, best interest says you need to pay attention to these factors, the child's views and aspirations. When did you know what your aspirations were going to be?
I'll get back to you on that when I let you know. It constantly. I remember being a kid who wanted to be a policeman, a firefighter, an astronaut, all of the common things kids want to be, and it changed daily.
Yeah, yeah. And so that's kind of that one is kind of an interesting one. I'm sure there are kids that have, and I have some in my extended family who know exactly where they're going. I went to a physical therapist yesterday who says, well, at the age of 12, I knew I was going to be a physical therapist because I broke my kneecap and went to physical therapy and found, oh, wow, this is fantastic. And so,
Hmm.
okay, well, good.
Yeah, I mean, sometimes you find out.
Yeah. So, how are you going to? The question then is, how am I going to ask this? Is there really a test that tests this? Not that I'm aware of. I can sit down and ask the children, but
Yeah.
what's a 3-year old going to tell me? And if this children, and if there are several children in the family, and I've got a latter adolescence, an early adolescence, a preschool child, and an infant, how am I going to get that information? Really,
Yeah.
they're not looking at the child's views and aspirations. They're looking at the parents' perception of a child's view and what their aspirations are for the child.
So,
So, so
okay.
this,
So that would be a lot more like, oh, I know little Jimmy likes to color a lot, so
uh,
maybe I can foster that within him. Or Susie likes to read, so I'll buy her some more books or, really engage her on that topic, as opposed to a parent who's just like, I don't know, that kid plays with blocks a lot, or, sometimes he draws on my walls. It's kind of crazy.
yeah,
So,
yeah. Well, I just don't know how that can be really well done across the children. But that's what it said. We do this
yeah.
across all of the children. Okay. The identity of the child, including age, gender, personal history, and background. Now, the identity of a child, while it includes age and gender and personal history and background, identity is a facet of self-concept, and self-concept is a facet of self-esteem. Self-esteem is the emotional feelings I have about myself based upon how I see myself and the multitude of self-conceptions that I have that deal with my age, my social interactions, my connection to my family members, whatever, my personal history. All of these self-conceptions create my identity. Now, again, we're really looking at a very complex process here. Now, is there a scale to look at? Well, yeah, at a certain age, I can administer the Rosenberg self-esteem scale and or the Osgood self-esteem differential, and it can give me some ideas about where their self-esteem is and some of the compounding factors. But you know, and I do, that when they hit adolescence, it goes like this, until they start to really crystallize. Because what we don't do is we don't educate children how to make this transition. Because when you were young, Braxton, your parents would say, "Oh, look at that little boy. Look how cute he is. Oh, he's walking." And all the self-esteem that you had came from them. But when you became an adolescent, you continued to seek out other people giving you that. That becomes a disaster. But we
Yeah.
never teach them how to make this transition to where they take over the management and foster the development of their self-esteem. So,
Yeah.
okay, family environment, family relations, and contact. I mean, I think that's important. I think you can look at that. If you've got a family environment and you go in and you say, "Oh my gosh, I really ought to have, the health services come in and look at this place." I mean, that you see that pretty well. But in most of the custody evaluations I did, the home environments were pretty good. The problem came in when mothers were given the home because they now have custody of the children, and the father lived in an apartment. And so when the kids came over, because apartments are expensive now, but back then they were expensive, they slept on the floor in sleeping bags. And that became an issue. What's the issue? They're sleeping on the floor, they're in a sleeping bag, they're still cared for,
Well,
but
yeah. But like this guy probably got thrown out of the house that he built, 3 weeks ago
yeah,
or, 2 months ago. And he hasn't had the chance to build up the same um, accumulation of possessions.
yeah,
Yeah, he wants to get the kids beds and all of that stuff, but he's also got all of the added costs of his divorce, all of that stuff. So, I mean, he might be able to buy them like, Goodwill beds or, just sleeping bags on the floor for a little while.
yeah,
But if that custody evaluation comes at the wrong time before he's, ready and is able to, you know, uh, get them the rooms all set up, he's at a severe disadvantage.
yeah. Now add to that, Braxton, this issue of family relations. And so the mother, the father, I don't care who it is, gets
Yeah.
custody of the children. And out of retaliatory behavior, they say, "No, you're not going over to this parents, grandparents. You're not going to see them or that side of the family." And all of a sudden, but we don't see that until after the fact. So the thing that one of the problems, the stumbling blocks, one of the problems with an evaluation is it's at the moment, and while we attempt to, project in the future, that's not it. It's how is it happening now?
Yeah.
And so honestly, if you're going to do a custody evaluation, then you need something that has a beginning point and goes across time for a period of time that gives you sufficient information that the defenses of, "Oh, I've got to be on guard. He's watching me, so I'll make sure. Oh, yes, they're going over to see dad, or yes, they're seeing the grandparents," until that becomes kind of neutralized. Then
Yeah. Yeah.
I can make a report. But that doesn't happen. And so what do you have? you have them coming back to court. And what does the judge do? Unless there is what? Reasonable cause to make a change in custody, that does not happen. And I have never seen a reasonable cause to say, well, she's not letting him see my parents. Oh, well, they're grandparents.
Well, they get distance. The wedge that was shoved in there just divides and makes the distance grow farther. They
Yeah,
lose a lot of the, like we were talking earlier, the generational kind of influences.
yeah,
Um, so that they lose out on a lot of stuff.
they do. They do. So, while these are good guidelines, uh, they're problematic in their own right.
Yeah.
And so you got to be careful when someone comes in and says, I'm making this recommendation based upon the best interests of the child. Because if I were coming in and looking at that, I would take them through each one of these elements and say, tell me how you came up with this, your conclusion about this and this one. And I would walk them through every single one of these elements of it.
Yeah, I know that the court puts a lot of weight into the custody evaluation. So if you can't, if you're the custody evaluator and you can't say, well, my recommendation is what I believe would be the best interest of the child, and if, Judge Openshaw is there taking them through all of these points and they can't back it up, did they really do that good of a job?
Well, and the question is, did the court, I won't say the judge, but did the court do a good job in the beginning? And we're going to talk about that
Yeah.
in a second here. So we can go through these. I'm not going to read through each one of these, but you can see, you know, how complex these are. If you're really going to do that, and you take that across 9 of my kids,
Yeah.
I'm, I'm going to tell you that takes some time. Okay, so Rule 4-903 says a request by the parties to the court would be sufficient if the court warrants such. The court has to look at it some. They don't want just some fly by the night request to initiate a child custody. But usually it comes like this. A request is made by one or both parties. Now, here's my problem with this. While this is the way it is, how successful will the desired outcome be if this is not a two-party agreement?
Not very successful, I would imagine.
No. And I can add to that this problem and the mess, and that is, let me just send this in. The problem with this thing here too is because it's not a two-party agreement, that to me is the first indication that there may be parental alienation going on because
Yeah.
of the degree of contention that's happened. So who does the party come to? To you. Okay. And you have to go to the judge. I mean, the parties don't go to the judge and say, hey, I want a custody evaluation. They come to you and they find an attorney and they're out shopping and saying, is Eric and Braxton really, are they good custody attorneys? I want somebody who is mean, someone who could just bite the bullet and tell them how this is. I mean, they're looking for an adversarial context.
Yeah.
So at this point, a decision whether it's going to be adversarial in nature or whether it's going to be proactive in nature is a critical turning point. And I think that's where the two attorneys get their heads together and say, how are we going to look at this? Because honestly, if we go through a custody evaluation, there is no winner.
Yeah.
Everyone loses.
Yeah.
And I know it requires a lot, but attorneys I know are bright. They look at things and they can say, and they are able to have insight into people, and you've seen enough people, and my friend Bob Sykes. I don't know if you know Bob or not. Um,
I don't know.
yeah, he's
So,
been an attorney for years, but um, you look at this, and a person comes in, and if they're coming in a hostile way, to go ahead and order an evaluation out of hostility is not a good idea. And it sets up a defensive and offensive position that will continue to emanate through the entire evaluation.
well,
So,
yeah, like you said, it takes time for each party to become comfortable with the custody evaluator. And if it was, if this wasn't a two-party stipulation, one party is really never going to get comfortable. They're
no,
always going to be on the defensive because they're like, well, you're just an agent of my ex-spouse.
yes,
So,
yeah,
regardless of whether or not that, however their perception is, is about that, like they'll just never be comfortable enough to actually give the proper data to the evaluator.
no. And you become triangulated in this process.
Yeah.
So you got him, her, and here you are as an attorney. And the other
Hmm.
attorney is triangulated. The only way to break that triangulation is the two attorneys come together and say, we need to sit down and talk about this. Do you really want to take that kind of hostility into this situation? I'll tell you, some are going to say, you darn right. Do you know what he's done to me or she's done to me? But
Yeah.
it's not a winning situation. Okay, so the attorneys go to the court. Once the court becomes involved, although, when attorneys become involved, it can be, I believe that's the first choice of adversarial or proactive. So, but once a court comes in, it is now adversarial. Why do people go to court? They don't go to court because the judge is so nice.
No, they go to court because they're like, well, we can't make a decision on this. There's no way we can even talk to each other without foaming at the mouth.
Right,
So we need somebody else to step in.
right. And they
Yeah.
assume that the court can make that decision. Now, it would really be nice if the court took a moment to really maybe sit down with the two parties and get an understanding. Uh, Judges I've worked with, I don't think this is done, but the judges I know are astute enough that if they wanted to, they could sit down with the parties and say, hey, let's really think this through. Are you thinking really using the catchphrase, best interest of the children? Is this really in their best interest? So anyway, that's a
Yeah.
concern. That once it gets there, we're headed for an adversarial situation. But the next thing becomes even as critical or more critical. So while one or both parents can request an evaluation, ultimately the judge is going to be the one who orders it and asks it to be completed. Uh,
Yeah.
and and of course, completion means we're going to do this much of an evaluation, and then I hope we can get to a settlement agreement. And we're going to talk about this again. But my contention is if these two people can't work through it through mediation, how do you think you're going to get to a settlement agreement? Out of fear, maybe,
Yeah.
you know,
Yeah.
an evaluator comes in and says something that it invokes some anxiety in them in the parties. That may help, but that fear is not going to be substantial across time. It will dissipate.
Yeah. A lot of people they're very hot-headed in the beginning of their divorce and they don't realize how long like the actual process takes.
Yeah,
Uh, and so they'll go, all right, we're getting divorced, and they'll file their petition and they'll start all of the proceedings. And then maybe about 6, 7 months in, they'll go, I thought trial was going to be a lot sooner than this. No, no, you guys have a lot of assets, or this is a really complex case. And
Yeah,
so just the discovery period is 6 or 7 months.
yeah. And that's
So
assuming they don't try to hide it from you.
yeah, and like it's going to cost a lot more money than people think. They go, oh yeah, I'll file my petition. I'll get my attorney for a little while. This will cost me like 10 grand.
Yeah,
If you're lucky, if you have the easiest divorce in the world, it'll cost you 10 grand. If there's any points of contention,
yeah.
it's going to double and triple in cost.
Well,
And
and then you add a
yeah.
25 to $30,000 evaluation.
Oh yeah,
Easy. Yeah.
easily. Yeah. And then, by the time that you actually get to the point where you've had the custody evaluation done, you've been litigating this, a lot of people lose the taste for it, and
Yeah.
they will. Um, that's why a lot of them eventually settle. Not
Mhm.
every case goes to trial, but um,
Yeah.
a lot of them are just too angry in the beginning to even consider um, sorting this out.
Yeah. So here they get tired. They're psychologically tired, but
Yeah,
they're financially drained.
yeah, as well.
And honestly, I think for some, the reality steps in. I've just spent $250,000
Yep,
and I'm going to lose my house.
yep. I'm losing my car. I'm losing the house. I have to. I had to move into this apartment that is a shoebox on top of other shoeboxes, and it causes a lot of negative feelings for these
Yeah.
people when they finally finish duking it out, only to realize that they could have saved a lot of hassle.
But then they blame
So,
each other.
yeah,
And who suffers? All of this was in the best interests of the child.
yeah. The kids are almost a foregone conclusion sometimes. They
Yeah,
just want to hurt each other instead.
yeah, yeah. Okay. So it's ordered by the judge. So I wonder why it is that the judge doesn't really look specifically at critically relevant issues of the best interest. For instance, the care, protection, the safety of the child, the vulnerability. If this fellow is and has sexually assaulted someone or has sexually abused, and I says had because not every one of them are pedophiles. You
Yeah,
know, and some of them may have acted out once on a child, totally wrong. And they should go to prison and
yeah,
they should go through a process. It doesn't mean that they're going to do that on every single child. But the pedophile, you got to be able to distinguish between those that are pedophile and non-pedophilic, offenders. So I think that I think the judge could look at this. Now, maybe he needs someone to look at this first. Maybe he just doesn't have time. I mean, those courts are backed up, but it adds a dimension of adversity that I wonder if we really need it. Could we stop it earlier? Okay, so the selection of an evaluator. Now, this one is kind of my cliffhanger. Okay,
okay,
because if we look at an evaluator, do the parties really have any say? No, the judge says, here are two or three names, and he gives you two or three names.
yeah,
Do the parties really get to review their true credentials? Do the parties get to talk with them and really get to see who these people are?
no,
And
not usually.
no,
Yeah,
no, typically not. And so basically, it is they've got this resume. Now, I reviewed resumes when we hired at universities, and I know how easy it is to pad a resume,
yeah,
and that's a problem.
yes, it
Okay.
is.
So in the state of Utah, like I said, there is no separate license. There is no mandatory certification. Basically, the only thing is you have to be recognizably licensed as a clinician by DOPL, and you have to be compliant with Rule 4993. So,
Okay.
what professions can do it? Well, the question is what clinical profession can't do it? Okay, clinical psychologists can, marriage and family therapists can, clinical social workers can, clinical mental health counselors can. Okay, and I'm not saying they're not competent to doing it, but I know, having developed a marriage and family therapy program, there was not a curriculum in that program, nor having reviewed programs around the country for accreditation, uh, did they have a program that specifically looked at being a child custody evaluator. And I would bet if you pulled the curriculum of every one of these professions, what you'll find is none of them have a curriculum that involves sufficient amount of information about custody evaluation.
Yeah. I mean, they probably have some like circles in their curriculum that overlap, but a lot of these people kind of have different careers that go in different ways.
That's right.
Yeah.
That's
So
right.
like a custody evaluation by a clinical psychologist and a clinical social worker are going to be very different things.
And my question then to that is, why don't we put some of those together? For instance, the clinical social work, I have two different degrees. I've had two master's degrees. So
Hmm.
the clinical social worker is unique in their ability to do a, a psychological kind of profile. It's called the psychosocial history of a family of
Hmm.
people. Psychologists aren't trained in that. Psychologists are principally trained in testing and diagnostics. They're good in that. Marriage and family therapists, they're fantastic about systems, the system operating in the family. And so, if we're going to do custody evaluation, why don't we put a couple of them together based
Yeah.
on our understanding first of really what we're looking at, which goes
Yeah.
back to this best interests. Are we really looking at, is this person, does this person have in-depth psychopathology? Is there sociopathy in this person? Is there psychopathy in this person? Uh, Depression. If a person's depressed, I don't think that rules out that they can't be a good parent. I
Yeah.
don't think anxiety rules that out. So the basic clinical syndromes are probably not as problematic if they're being treated. If they're personality disorders and they're more in-depth personality disorders, the third order personality disorders, we get the borderline personality disorder, then we've got to start saying the paranoid personality disorder. We've got to begin saying, oh, yeah, there might be some problem, but maybe they could get some help. So, so why don't we do this? Well, it's the same reason why on our campus, psychologists are in one college, marriage and family therapists are in another college, social workers are in another college, because we don't get along.
Is there really that big of a rivalry? Because
Well, I'm making a little bit more than it probably is, but
no.
there is a pecking order,
Okay.
because marriage and family therapists, social workers, clinical mental health counselors, they have a master's degree. Clinical psychologists have a doctoral degree. But there's some of us, like myself, who has the equivalent of two doctoral degrees.
Yeah.
Okay. Um, and I've been trained in the use of many of the tests that psychologists use. So when I did mine, I did use some of those.
Yeah.
But the point of it is why don't we work together if we're really going to do that? Because if we really want to get to the best interests, we need a combined effort of looking at this. No, we don't.
Yeah. No, it seems like each one of those professions kind of has a part of the whole, you
Yeah.
know.
Yeah. I
So
don't know much about the training of the mental health counselor, you know, but I do know the other three pretty well. So having been an adjunct in clinical psych and developed the marriage and family therapy program and worked very closely with our social work program and being licensed in those two. So I got more of an understanding there. So let's look at Rule 4-903. What are the minimum qualifications? This is what we're looking at. Not that we are looking at anything here that gives certification. 18 hours of child custody related. Oh my gosh, there are lots of related types of things each 2 years. Oops. Specialized knowledge and ongoing training in and through, not limited to, topics related to child custody. Family systems and dynamics, research and laws pertaining to divorce, separation, child custody in an ever-changing and dynamic world. Boy, that's a mouthful. Facilitation
yeah,
of the developmental needs of the child in the context of divorce. Okay. I mean, these are good areas. They just don't constitute certification. You
yeah,
look, and you probably have. If you look at the certification of uh, those in substance abuse, there is a very, very specific criteria of curriculum for them to be involved in. So they go on and then specialize in it. There's
yeah,
nothing out there to help us specialize in child custody evaluation. So why are we doing it?
yeah,
I don't know. Just my
yeah,
soapbox. Appointed by the court. If this is the case that is appointed by the court, then the court will appoint a custody evaluator, or a couple of them, and say, you find it out. They'll apportion the payment of the evaluator's fee among the parties, which means, if I get this right, because I make more money than this person, I have to pay more than this person.
yeah,
Okay, I know. Equitability, I'm for equitability. I don't see a problem with that. But do they really have an understanding? How many people are getting money under the table? I know a situation where the father's not paying any child support. And yet I know he's working, but everything he acquires is under the table. And he gets paid well under the table.
yeah. But there's no
Why?
way to prove it. It is, yeah,
No, there is no receipt.
yeah. There's no paper trail for
That's
that.
right. That's right. Okay, specify the dates that the evaluation will start and finish. Well, I just don't know about this finish time. Okay, I know the court wants to get things going for the children and get things ended. But like I said, I can tell you, I can put on a pretty nice face for a long time.
Yeah,
I can say, oh, that Braxton. Well, I tell you, I don't want to talk bad about him, but you have to know, and but certainly negates what I just said. Uh, but what we're doing is there really is no finish point. How many cases of custody have come back after the initial decision? I
quite
have no
often.
understanding, but there's a big number.
It is big a number. They even have their own specific category for just petitions to modify
Yeah,
after the ruling or the decree or something because things change.
things
Yeah,
do change,
yeah,
but do they meet the criteria of reasonable?
yeah. And some of them do, some of them don't. Like
Yeah,
some people do it to be malicious.
yeah.
They're like, oh, you moved, so I'm gonna throw the petition to modify it. And it's like,
Okay.
okay, I moved within the same city. That doesn't really count,
But
you know?
again, it's that thing, Braxton, of why didn't we catch this in the first place and deal with it?
You know?
That's my main contention of this whole first part is why don't we catch it in the first place and
Yeah.
deal with it? So, okay, specified factors be addressed and require the parties to cooperate. That that is such a ridiculous statement. I
Yeah.
don't know how, unless the judge is going to be there 24/7 or an attorney is going to be there 24/7 to watch, no way on this green earth or the poll caps will we require the parties to cooperate.
It seems like a hard thing to enforce. Oh, like you can't really be sanctioned, like you're not violating an order.
No,
Even like if the court orders you need to cooperate, like that's a really gray area. Like, yeah, I let the custody evaluator into my house. Yes, I answered all their questions fully and honestly. Did I give good answers? Well, I mean, I cooperated, didn't I? It's not my fault you didn't ask the right question, or um, you just didn't see the things that I hid. You just didn't catch me. There is a pretty big gray space, I think, on what is considered cooperating and what isn't. Because I know
yeah,
even um, getting somebody on a like motion to enforce and for sanctions is kind of hard to do.
yeah,
You need to prove that this person has knowledge of the order, had the ability to comply, and willfully chose not to comply. So like just arguing that can be hard sometimes. So
well,
I've seen my
add,
boss, but I don't actually argue in
so
court. Yeah.
add to that. I bring I bring my attorney in, and I have evidence that the other party has violated the agreement. How often do you find the judge really coming down and saying, okay, you violated this agreement, therefore you're going to spend 2 weeks in jail?
Not often.
Yeah.
The the jail thing is a kind of an egregious thing. I've never seen it happen, but I mean, I'm just Eric's legal assistant, so I don't have as much experience as him. I know he's seen some crazy things, and I know that even if you go to trial and um, they give you a judgment of $10,000, you
Yeah.
still need to find a way to enforce that. Just because somebody gets a judgment against them doesn't mean that they always pay that judgment. You know,
No, no.
so
And,
like enforcing the rules is a very difficult thing to do sometimes.
and even when you have evidence, I'm thinking of a case Eric and I talked about a little bit of a father who has evidence that the mother, for an extended period of time, was living with another man, was bringing drugs into the home, was supplying his adolescent children with drugs, not requiring the children to go to school. He had a PI come in and took that forward to the court, and the court just dismissed it. And I think that's amazing. They dismissed it, but that's the
Yeah.
case. So, okay, who qualifies to provide the court with a custody evaluation? Well, the ability will vary from profession to profession, and thus, in my opinion, this variation is going to affect both the quality of the overall evaluation, even though basic qualifications of the profession set out in this Rule 4-903 are met. You're
Yeah.
going to get different qualifications. Therefore, there is, while 40903 and the 10-30 and whatever they are, give you this guideline, uniformity doesn't happen. I can fill in blanks to fill in each of those things. But
Yeah.
uniformity of quality of assessment, diagnostic assessment, is not present. So here we are. We go request, goes to the attorney, to the court, order the judge, selection of evaluation up to a settlement agreement. Like I said, the intent of what 409-3 and 10-3-30, if I've got the numbers right, say is the purpose of the evaluation is to do this mini report, to come back to the court, to get together and come up with a settlement. And my contention is, unless you scare the crap out of these people into compliance to a settlement, and I say when you force someone into compliance does not mean that it will be maintained, and they agree to the settlement, for the most part, you're going to get the same result as you did at mediation. We require you to go to mediation. If they can't mediate this out, how in the heaven's name do you think you're going to get them to do that in a settlement agreement? Well,
Yeah.
like I said, unless you scare them.
Yeah.
So here's the settlement report, they want is to reduce the time and expense of a full report. Okay, I agree. We want to reduce time and expense. I don't know two things. One, how many settlement reports do get people to settle? And two, of those people who settle, who really agree to and abide by the settlement agreement? That's a significant question that ought to be asked and researched out. Because
Yeah.
if that's not the case, then you're really not reducing time and expense, and the cost on children is great. Now, there
Yeah.
will be a lot who disagree with me, but this is one man's opinion, Braxton. Okay. Disclose the evaluation findings in a way that's less adversarial and damaging to family relationships. I would really like to see how that happens. Because the moment they step into this, it is adversarial.
Yeah.
And of course, the evaluator cannot give any information up front to these parties until they come in to this settlement agreement process.
Yeah.
Uh, that's, I think this is problematic. Good idea, problematic in getting it.
Yeah. I mean, if they weren't going to settle this before, and if they didn't settle it in mediation, um, there really isn't a good chance that they're going to settle in a like
No,
a settlement conference or even a judicial settlement conference.
no,
Yeah.
I'm afraid that's not the case. And so again, I ask the question, have we done the children of justice?
Yeah.
Question. So here we get down, valuation gets, I says the initial intent is to devise a settlement. If that could not be acquired via mediation, what makes one think that such will occur out of the evaluation, other than the potential threat that manifests?
Yeah.
So we've said that. I don't want to keep saying it. So missing steps, in my opinion. Okay, so we've discussed issues around child custody. It's just my opinion that there are critical steps. Oh, I got a spelling error in there that are missing. So what do we continue? Well, one of the things here is we we get a decision to carry out a custody evaluation. It's revisited. We've got to come back here. We really need to help these couples understand what they're going through. Anger just clouds the memory. There are some who think that if I were to draw an X and Y axis and I started at zero on both, well, if I put logic at 100% on the X axis and emotion on the Y axis starting at zero, if I start just gradually increasing emotion, most people think that logic will drop down on a one-to-one basis, kind of like that. But the reality of it is, as soon as emotion begins to start, logic goes like that. It drops off dramatically quick. So,
Yeah. It's kind of hyperbolic. Just, you know.
Okay. So at this point of coming back to the attorneys, I think they really need to continue to, do we continue the evaluation or should we look at some alternatives? They have to be given that opportunity, but they first have to be educated. And it might be, getting the two attorneys and a an integritous custody evaluator to come in and to do a little psychoeducation to help them understand in a large context, two attorneys, two parties, evaluator to walk them through this is what you're going to be going through. And so they go into this with a clear understanding of the decision that they're making.
Yeah,
And that may mean that we may need to help them with a little stress reduction, whatever, so that they're open to listening.
yeah,
So anyway, while the selection, back to selection process, and 4-903 is method identified, I think there's some alternatives. So the point of this is we're going to look at some of the requirements of a custody evaluation if we're going to go through it. But I want to really look too at what are the alternatives? You know, how
yeah,
can we help families? No, I don't want the couple to stay together if they don't like each other, but it's okay not to like each other and still be able to be amicable and facilitative of the development of children.
yeah, yeah. I mean, an alternative method would really help a lot of people, I think. The reevaluation and then the offer of maybe an alternative method would help because I know a lot of the stuff that I've seen. Some of the first questions that are asked are, well, what's the custody situation right now? As
Mhm.
opposed to, well, they just divorced, they just separated, not actually divorced. But a lot of people aren't even given the chance to exercise equal custody.
No.
Um, that they just don't even get the option. So, and I think a lot of that is the underpinnings of the tender years doctrine, like we discussed,
Yeah.
and a lot of just, well, this is what they're doing. It seems to be working. Why would I want to upset that balance on a maybe?
Yeah.
So,
Yeah. Well, hopefully what comes out of this whole thing, Braxton, is, whether attorneys agree with what I say or don't agree with what I say, or whoever watches this, that's neither here nor there. What I hope most of all is it sparks interest in looking more creatively at helping people getting divorced work together to benefit the children.
yeah, yeah. And I think a lot of people just kind of forget about that. They kind of get wrapped up in the emotional turmoil of the divorce and forget that hey, we have kids that we need to really focus on. Um,
Yeah.
so yeah,
So
wonderful.
anyway, that's kind of where we are until next time.